The right of publicity, okay, is the right of every person basically to commercialize on their identity, okay? If you use a person's identity for commercial purposes without their written permission, then you in fact are violating their rights and they're entitled to money judgment, okay? Now, rights of publicity are considered by many, many courts, no federal law governing this, but by many, many courts, to be like a property right. And you have a property right in your identity. So when you die, like all your other property, it will pass through your estate. And your heirs will now own the right of publicity that you have and be able to basically protect it and license it and use it, okay? Now, again, because most of this is governed, if not always, by state law, it gets difficult figuring out how long this particular right is going to last. In California, it's 70 years. I believe in Oklahoma, it's 100 years. I don't think Tennessee has any expiration date because of Presley, but different states have different time periods. And basically the right arises in post-mortem where the person was domiciled at the time of their death. But it is a right that's protectable. But it does raise the question, what is a person's identity, okay? And to me, a person's identity is any aspect of a person's persona which is depicted in a manner which symbolizes or identifies that person. Think about it. You use a person's name, that's their identity, their likeness, their voice could identify an individual, okay? A nickname can identify an individual. Okay. An event can identify an individual. A phrase that is so identifiable with a person can identify an individual. Elvis has left the building is a phrase, I believe, which would identify Elvis Presley. So therefore, you can see there are many, many elements of a person's persona which could, in fact, identify an individual. Social media doesn't give you freedom. Simply because it's on the internet doesn't mean, okay, it's fair game, I can use it. As the advertiser found out here, when they ran across a picture of Katherine Hagel walking out of Duane Reade. Those bags have the Duane Reade name on it. And they thought it was fun. I'm sorry, fun is not the right word. They thought they could, because it was on social media, simply take the photograph and use it. Well, they couldn't, okay? Because she sues for $6 million, claiming again that her rights of publicity have been violated, using her identity for commercial purposes without her written permission. So those are the things you really have to keep in mind, because this is an area that we constantly run up against in terms of people claiming that their rights have been violated. Third-party rights. People own copyrights, they own trademarks, they own their identity, and you just don't have the right to use it for commercial purposes without their permission. Simply because you've decided to call something a press release doesn't mean that all of these legal principles go out the window. Calling it a press release did not immunize it from the fact that these issues, these third-party rights issues, will arise. So it's something to always keep in mind.